pardon to mention, my lord, and OGLS matter, my lord. The opposite parties are proceeding with the work, my lord. If possible, my lord, may kindly be taken up.
Fresh matter.
Is the almost fresh, my lord. It was list
Question of
opposite party appeared, intervened, but after vacation.
Vacation kind they were it will automatically come. We just listed only the fresh admission matter.
After vacation, any?
No, don't give the memo for after vacation.
Lady and 55 years above method. More than
Oh, by bail pay. Division bench.
My lord, same, your lordship. It's a plainly lady more than 9 years in custody. This matter, my lord, OGS matter. OGS matter, this matter.
May I please, my lord? My lord, item number 45. May kindly allow this matter after vacation, my lord. My file is not with me. Item 45. 45, my lord.
45. WPC.
For fresh admission.
25017 of 24. Sebak Kumbhar.
My lord.
All right. Land counsel for the petitioner seeks for an adjournment after.
My lord, may kindly fix the date, my lord.
We'll see that next.
Much obliged.
Wait, please, my lord. Lordship, item 43, my lord, from the list.
Yes.
That may be taken up today if your lordship permits.
Passport one paragraph. Keeping this in view and as a matter is pending for consideration of the division bench, this court is of the opinion that this matter should be tagged to the writ petition number 23850 of 2017 pending before the division bench for effective adjudication of the issue involved. In the meantime, as has been noting is that this case has been disposed of by a common order passed on 22nd of September 2022. That order, my lord, I could not have got it downloaded because that has not been uploaded. This matter may be taken up after vacation so that I can verify that order. And
the order reads like this: that London Council for the petitioners in all these three writ petitions placed reliance on Gazette notification of Orissa dated 8th March 2019 and submits that in view of the subsequent developments, petitioners are not interested to praise this petition at this stage. Accordingly, writ petitions are disposed of. Interim order passed earlier stands vacated.
That has been passed in the my lords. That I have also verified my lord's brief in that blue copy that there is this has been disposed of in a common order. Probably this is the order.
Yeah.
I am to verify that along with my case whether present that could be covered under that or not.
There is some notification is there on 8th.
Yes, I am to verify that.
You want this order copy?
I'm lying against a file will never updated him, downloaded him.
They do. ये जो ये सो जब पर सिग्नेचर अच्छी तब वो इरेजर मारते और किन तरह आउट कॉपी करी दीटा कॉपी करती दीटा कॉपी कर दो इरेजर मारला फिर आउट एक्स्ट्रा कॉपी यस नेक्स्ट आइटम
After vacation,
yes,
I'm obliged.
He wants to verify the order dated 22/9/2022 fasting document 23850 of 2017, which was disposed of as per order dated so also, along with other connected petitions. And he further submits that he is not having a copy of the said order, and therefore the matter may be taken up after ensuring puja holiday, and if order copy may be supplied, let the registry supply the copy of the order dated 22/9/2020 or something. Mr. Roth, just wait for 2 minutes.
Yes, yes, matter.
Item number 2.
May please alert it. The petitioner is a landless and homesteadless person. He has made prayer to give direction to property parties. No, directly. No, this court will give directly issue a direction. Have you made an application for the authority? My lord, under the legal provision. That I have, though I have averred in the body. No. Have you made an application for the competent authority? Competent authority for what is that document? But that document I have not enclosed.
ଆପଣ ପାଖରେ ରଖିଥାନ୍ତୁ ଡାଇରେକ୍ଟ ହାଇକୋର୍ଟ ପଳେଇଲେ ମତେ ଏଠି ଗୋଟେ ଜମି ଦେଇ ଦିଅନ୍ତୁ କେମିତି ହାଇକୋର୍ଟର ଜମି ତ ସେଇଟା ହାଇକୋର୍ଟ ଦେଇଦବ ଆପଣଙ୍କୁ
ସେଟା କନସିଡର ହେଲା ନାହିଁ ତାପରେ ଆମେ ସେଟା କଣ କରିବା I may be permitted to withdraw
Yes, next.
My lord, my lord, with the liberty,
Yes, next.
observation may kindly be given, my lord.
Yes, next.
Item 3.
Annexure 4 to
Not to request. Yes, it's not to teach dispute.
So to say
There's a vacation notice. Vacation notice each.
On a very alternative media available. This board of next.
Item number 4.
Item number 3.
Yes. Approach the DRT. Alternative media available. That is pulling up. Yes, next.
Item 4.
Item 4, Annexure 11 regarding compassionate allowance be considered in terms of Annexure 9. So, addressed to the Secretary Department of Home, page 52, Annexure 11. So, at the time of consideration, Annexure 9, two proposals were sent, but Home Department accorded proposal aspect of Annexure 9, one of the applicant, but my case is not being considered.
No.
It is a case of my lord.
No, this is in respect of one Sabita Behera. Please come to Annexure 9 you are referring to. This is written by Deputy Secretary Government. It is addressed to the DG and IG of Police, right?
Yeah.
Sanction of the compassionate allowance, so and so. In inviting reference to the letter and subject, I am directed to say that the Finance Department, after careful consideration, have been pleased to agree to the proposal sanctioning compassionate allowance in favor of so and so. Such allowance should be minimum of the pension amount in accordance with. So how you are connected?
No, it's in one of the instance, Finance Department has prepared a guidelines how to assess the condition of the person claiming compassion.
Have you submitted any representation?
Annexure 11. Page 52. That may be considered. See, guidelines of Notila. Say how to assess the financial condition and reasonableness.
Have you given an example of that lady has also?
Yes, Annexure 9.
No, you are an employee under?
Employee under District Judge Balasore.
So under what? Under which rule?
My lord,
under which rule you claim this?
My lord, rule 46 of the OCS pension law 92.
So you not allowed that?
No, my lord. In case of discretion, my lord, it may be, but before granting the compulsory allowance, they have framed the guidelines through the judgeship or through the department administrative head to conduct an inquiry. Is there any?
Who has framed this rule?
Finance department.
Finance department. All right.
They will consider. So the concerned department will send the proposal to the finance department. After it is being concurred by the finance department, so the concerned audit department will assess. They will sanction the compulsory allowance. So to the
ସେଟା କେବେ ରହିଥିଲା?
ଏଇଟା ସେ ଦେଇଥିଲେ ଏଟା କୋଡିରେ ଆନେକ୍ସର 9 ଟା କୋଡିରେ ଇସ୍ୟୁ ହେଇଥିଲା 27/2/20 So according to the guidelines, they will conduct the field inquiry and family status.
You are superannuated since 1985.
Reinstated dismissal पर reinstated only. पुणी again proceeding as report, we shall restore करदेंगे.
Again you are dismissed.
Again dismissed.
It was a punitive action. It was a punitive action. You were not entitled to anything.
Anything. So, Rule 46 कहला, in case of major punishment like removal and dismissal, if the authority considers, so Rule 46 टा हम पेंशन ले अच्छी, विशेष पेंशन ले नहीं.
अपन मोटे मेंशन कर लेते हैं. Government कौन?
अपन government नहीं repeat.
आगे.
Report कर देंगे Rule 46 ना. कल तो लिखी देले
पारा 9 ने खाली से तीन लिखा.
और ऊपर हमारे लिखी से खाली मैं तो 46 पेंशन में prescribes that in case of dismissal removal.
Pension rules 1992. आप लोग पर boy नहीं.
Sorry, madam.
Sorry,
मैंने I think अच्छी है.
Counsel for the petitioner in this petition has relied upon Rule 46 of the OCS Pension Rules 1992 for getting relief for the petitioner, but it admits that he has not got OCS Pension Rules 1992, and therefore the matter may be taken up after ensuing Puja holidays. Let it be listed after Puja holidays. Yes, the client also should read the order. Yes.
Sir. My lord, item 3, please consider the matter by ସେ ଯୋଉ 3 ଲକ୍ଷ ଟଙ୍କା ଲୋନ୍ ନେଇଥିଲେ ବର୍ତ୍ତମାନ 1 କୋଟି ଟଙ୍କା ସେ କ୍ଲେମ କରୁଛନ୍ତି ବ୍ୟାଙ୍କ ଏବଂ ତାର ମାଲ ତ ଘରେ ଅକ୍ସନ କରିଦେବେ ବୋଲି ସେ
सर्विस है जोड़ा तो.
Disposable. Yes. Of course, yes. Next.
Item number 5.
Yes.
The opposite party.
Mr. Bari. Mr. Padi, it is your matter.
Yes, my lord. This may audible, my lord.
Chat is not there.
May audible.
Yes, you are audible, but wish to place this case on behalf of Union of India. Are you able to hear us?
Yes, my lord. May audible, my lord.
Yes, you are audible, but are you able
My lord,
to hear
we
us?
need time to file a counter.
Counter नहीं, it is your case.
We have filed. We are petitioner in this case. We need some time, my lord.
Content petition has been filed by before the tribunal, and it has been adjourned from day to day. Since the writ petition is pending, we are unable to comply. The person has been retired, my lord. The pension has not been disbursed due to pendency of this.
Let's keep it to after reopening 22nd or 23rd.
All right, Mr. P.K. Padi, Learned Deputy Solicitor General of India, pray for an adjournment after ensuing Puja holidays. Raise this matter on 22nd October 2024. It is made clear the Learned Counsel for the opposite party that The writ petition has been filed challenging the order passed by the Central Administrative Tribunal, Cutter means Cutter, in way number 816 of 2019 and RA number 260/009 of 2021. And the petition is pending before the Learned Tribunal, which is adjourned from time to time on the request made by the Union of India on the ground of pendency of this petition. Stop. It is made clear that no further adjournment shall be granted. Yes, next.
The pay submission, my lord.
You were heading the state.
Item number 6.
Compensation in lieu of land acquisition. Annex to 3 representation pending before the opposite part number 2 collector judge 4. That may be disposed of.
Kichi painati, response kichi painati.
Item 7.
Item 7, this is an eviction matter, my lord. And my prayer is to, I am an encroacher, no doubt, but the tahsildar, opposite party number 4, he has not adopted the proper procedure to evict me, and without any notice, without any intimation. He is going to evict, and some portion, some houses of that plot has been demolished. However, that is a butcher land, and it has been illegally leased out. And that reason, another case has been coming to cancel the lease. And I am the encroacher. I am a poor man.
Have you filed any representation?
My lord, representation I have not filed because I am not getting any chance. My lord,
Have you been removed from that place?
my lord,
Have you been removed from that place?
Evicted.
But what is it? I can come to annexure, that notice, annexure 4, page,
Yes, 19. Annexure 4.
again.
Jabardast.
The Councilor has issued the general notice and it has been hanged in conspicuous place.
7/7/2026 ତାରିଖ ଦିନ ଉଚ୍ଛେଦ କରାଯିବ।
ଆଜ୍ଞା ସେଥିରେ ନୋଟିସରେ କିଛି ଭାଙ୍ଗି ଆଜ୍ଞା ସେ ଯୋଉ ମୁଁ ଚାହୁଁଛି ଆଜ୍ଞା ମୁଁ ଛୋଟିଆ ଦୋକାନଟେ କରିକି ରହୁଛି ତ ମୁଁ କହୁଛି ଏଭିକ୍ସନ ଅର୍ଡର ହଉ ଇଟ୍ ଇଜ ବଟ୍ ଇଟ୍ ସୁଡ୍ ବି ଇନ୍ ପ୍ରପର ୱେ ସେକ୍ସନ 9
Representation to be filed, not in. Yes, next.
Item number 8.
my lord interim order
File with no interim order. Yes.
interim order
Yes, item number 8.
This is the first time before a lordship. I have no second copy of the requisition has not been filed, my lord. Wrong letter has come to the honorable single judge. Your lordship, I will file a second copy. Your lordship, I have this.
So what is your prayer here?
Prayer, my lord. This is a loan amount of rupees 49 lakhs. As per the credit guarantee scheme, my lord, 20 lakhs have been covered, my lord. Another 29 lakhs I have to pay.
So why have you come here, not to the tribunal?
My lord, your lordship is right, my lord. Only they have to consider my application towards CGME scheme, my lord. That is the thing.
You have received that 13-2 notice.
13 to notice, my lord.
Yes, thereafter you have to file your representation.
Representation 60 days time, my lord. 60 days time
that period is already over.
No, 60 days time was not yet been over, my lord.
27/2024 ର notice.
27, 28, 29, my lord.
29
ଏବେ 10 ହେଲା।
This is repetition prior to the 20, sir.
notice ରୁ ये ଦିନ ନା ଯୋଉ ଆପଣ କେବେ file କରିଥିଲେ?
ଆଜ୍ଞା ମୁଁ
देखिए surface area को 60 days from the date of notice.
date of notice. That representation is pending. Let me
काई representation काई
मतलब representation ଟା ମୁଁ annexure କରିନି କିନ୍ତୁ
ने रखिनो रखतांदु
ଆଜ୍ଞା
Has it been disposed of, Mr. Sahu?
My lord,
Representation था
yes, sir, this representation dated 28/5/2024. Subsequently, our 13 to notice was
13 to notice टा देखते 27/2024 रे Now, 3A कहला if on the receipt of the notice under 13(2) the borrower makes any representation or raises any objection, the secured creditor shall consider such representation or objection. So and so time भी दिया है जी तादेरे.
ଆଜ୍ଞା
तो ଆପଣ representation file କରିଥିଲେ କି?
ଆଜ୍ଞା ମୁଁ ଦେଇଥିଲି 28/5 ରେ ଦେଇଛି
अरे आप ପରେ ଦେଇଛନ୍ତି କି?
ନା ପରେ ଆଜ୍ଞା
ଦେଇନା ତ ଆଉ
ଦେଇନି ମୁଁ ସାର୍ ଗୋଟେ ପ୍ରେୟାର ସାର୍ ମୁଁ ଗୋଟେ ସିମ୍ପଲ ପ୍ରେୟାର ସାର୍ as per the scheme provided by the
ଆପଣ ସେୟାରକୁ ମେରିଟ୍ କୁ ଯାଆନ୍ତୁ ନିହାତି
ରିମେଡି
ସାର୍ ଗୋଟେ ରିପ୍ରେଜେଣ୍ଟେସନ ସାର୍ ଦେବି
ଆପଣଙ୍କୁ ସେଇ ନୋଟିସରେ ସେଇ ନୋଟିସରେ ଲେଖା ହେଇଛି ୟୁ ଆର୍ ଦେୟାର ଫୋର ଟୁ କଲ୍ ଅପନ୍ ସୋ ଆଣ୍ଡ ସୋ ଆପଣ ଲେଖି ଦେଉଛନ୍ତି
ସାର୍ ମୁଁ ଗୋଟେ ସାର୍
ଆପଣ ନ ଦେଇକି
ରିପ୍ରେଜେଣ୍ଟେସନ ଟା ଦେବି ସାର୍ ଟିକେ
How can we say that? With that period, what is the further progress?
yes, my lord, that is 13/4 has already been
Look, the Land Council for the you are for Union Bank of India, Mr. Sahu submits that even though notice under section 13(2) of the Surface IR was issued under on 27/2024, the petitioner has not submitted any representation in terms of 13(3)(A, and in the meantime 13(4) notice has already been issued. In view of the state of affairs, since alternative remedies available, we are not inclined to solve this.
Sir, DRP, sir, TBT, sir, protection, sir, debe, sir.
No, yes.
Sir, I did, sir, 2 weeks, sir, debe, sir.
13(4) notice को challenge करो तो out
आया।
presentation of one क्या? Yes, next.
Develop.
Yes, Mr. Mahanti. कौन है prayer representation हो गया. Allow direct instrument to dispose of GR Swanso to certify
1929-1 GLS.
see annexure 3 to dispose of the direction. Yes. Next.
Item 10.
Last notice you had directed the state to take instructions as to why they have not acted upon section 14, even though an order was made by the collector.
Pass over.
I was not clear. There is an IA which I filed in the meantime that has not come on board. That is IA 13676 of 24.
ଗୋଟେ IA କଣ ଆସିଛି ଆଉ ଗୋଟେ IA ଫାଇଲ କରିଛ?
How would I file? 13676. 13676
of 2024.
24.
ଆପଣ କପି ପାଇଛନ୍ତି ସେ IA ଟା?
It has been served. It was served on the state council.
Prayer କଣ ଅଛି?
Where is we have in the meantime?
No, that interim application.
Yes, in the meantime, we have seen that certain orders have been passed by the DRT, affording an opportunity of depositing money to the creditor. Now, that
let it come with that.
No, that we want to leave from this court. That while this matter is pending, I may use the appellate authority or the DRT for vacating that order. Only that leave I want.
That advocate submits that he has filed an interim application filed IM number 13676 of 2024, and this matter is the state that will be said interim application. Land Council for the state submits that he has not received the copy of the interim application.
Receipt as well.
Let a copy of the copy lady on the top.
They have filed Saturday, so that's why I did not. They have filed Saturday.
Acha, Saturday filed it. Let a copy of the interim application be served also. Here is next.
Okay, actually,
Item number 11.
My limited ignorance, my lord. Annexure 5 may be kindly disposed of them. Pending before the opposite party number 1.
କିଛି କମ୍ୟୁନିକେସନ ପାଇନାହାନ୍ତି କିଛି କମ୍ୟୁନିକେସନ ପାଇନା ନେକ୍ସଟ 5 be disposed of. Next.
Item 4.
Mr. Pradhan.
Prefer after that puja
Right, after puja holidays.
Item 13.
Mr. Mishra, what is this matter?
Madam, to remember this order of the tribunal was under challenge.
Why filing of dispensing with the filing of certified copy of the order? Is there any connected matter or what? You are challenging the order of the
Certified copy of the order of the tribunal. That order is under challenge. Since you have not filed certified copy, so dispensing
No,
has
we
been.
thought that there is in some other case that order is there, certified copy. That's why.
Ma'am, similar orders. Common orders were passed, so it was filed in other cases.
Okay. What order has been passed in that other application?
Matters have been pleased to dismiss the
order
on the ground of dealing.
What order do not?
एक आपनकर order ଅଛି.
हाँ सही केबे केते नंबर
लॉन्च कर दिया.
Yes, Mr. Mishra, they pay.
May
Yes.
Matters will permit.
ନାଇଁ ଗ୍ୟାପ ସେ ବର୍ତ୍ତମାନ ଆଉ ଗୋଟେ ଅଲଗା ଟାଇପ ର କେମିତି ଅର୍ଡର କରିବ ଗୋଟେ ହେଇଛି ସିମିଲାର ଆଇଡିଆ ମ୍ୟାଟର ଯୋଉଡାକ ସବୁ ସେଇଆ
because Matters took note of my submission in the paragraph 1.
ସବୁ ଲେଖା ହବ ଯାହା ଲେଖା ହେଇଛି ତା ଦେହରେ ସବା କେତେ ନମ୍ବର ଟା ଖାଲି କହିଦେବେ
ଆଜ୍ଞା
WPC ଏଟା dismiss ହେଇଛି କହୁଛନ୍ତି
then Matters the entire batch this item 13 item 13 14 then 16 to 25 and item number 49
ଏଗୁଡ଼ା ସବୁ କମନ ଅର୍ଡର ହବ ହେଲା ସେ ଯୋଉଟା ମିଶ୍ର ଦେବେ ତାର ନମ୍ବର ଟା ଦେଇଦେବେ ସେଟା ବାହାର କରିକି ନେଇପାରିବ ହେଲା
I was only trying to pursue Matters because on merit these petitioners don't have this.
All right. Yes, next item. Give that number, huh?
Ma'am.
Yeah.
During lunch.
Yes.
Item number 15.
My pleasure, sir. Challenging the inaction of the opposite parties in not considering the application of the petitioner for rehabilitation external annexure 4 series is pending since 16/11/21, my lord.
You have not received any communication?
My lord.
Annexure 4 series.
My lord.
Pending before whom?
This is my lord. 121, my lord.
Copy number 1 pending, which is for you. Yes, next.
Item 26.
Sorry. Extra copy I have to Railway Council. It was urgent to
Similar matter.
It is similar. So railway copy copy I have absent or something.
Delay upon.
Yeah.
Yes, swine bill. Senior panel council ଲେଖା ହେଇଛି
vacation ପରେ ନା
ଅଛନ୍ତି
26. Item 29.
Mr. Mahanti.
29 group.
Mr. Mahanti, Land Council for the petitioner submits that will serve a copy of the writ petition on the London Council for the Railways.
Railway.
London Council for the Railways. and the matter may be taken up after
After-
the
26
Details, sir.
of the Satish details.
Item 28.
Mr. Gyanalok Mahanti.
नहीं तो सर से यूनियन ऑफ इंडिया अर्थात 27
Satish.
यूनियन ऑफ इंडिया सेंटर पर पूर्वटा 26 हमारे मंत्री निरंजन
Item number 29.
No, you are in item number 27 from Union of India Senior Panel Council.
That you have to serve a copy on you, and it will come after the
Appearance will be noted. It representation to Tahsildar.
28 ର କଣ ଅଛି representation?
ଜିଲ୍ଲାପାଳ କନ୍ଧମାଳ annex 2.
अच्छा, the annex 2 to be disposed of. Okay. So,
Item 29.
Your Lordship,
item 29 to 35.
item 29 to 34
See you.
and item number 40. 8 items. Similar, only pray for similar order dated 3-10 in 24661.
WPC 24661.
24661 of 2024.
24661. 24661 of 2024. In
Similar order.
also 2024 है ना same model.
My lords, item 30 to 34 and 40, 6 cases have slightly different prayers, slightly different.
ठीक तो आप dispose कर दो तो yes next item number
Item 36.
Headlines.
Mr. Milan Tango. Letter कौन है? One method.
NIS self obligation against sell notice each.
Shall notice.
Or one cooperative. Debt recovery, delivery of position. Series of applications, certified copy of order.
18/7/2024 is the owner asked to attend. The collector is the competent to provide the magistrate. Taking
So
over
you
the
put in the order.
private person or this one.
Put in the order here.
The 14 is a person, the private person with the eye very only. They only if you do the application of so and so, judge put along with this so and so in which he has paid collector so and so for providing all assistance so and so. Take position of the following. On verification, it is revealed that the authorized officer has not filed acknowledgement of receipt or demand notice from the loanee. Authorized officer has also not filed any acknowledgement possession notice after adopting all procedures for taking over the possession so and so.
And 14 has not been complied.
After auction ceremony.
Authorized officer has not come. Bank has not complied 14.
The requisite documentation. So due condition as provided under section so has not been maintained
Yes.
by the firm.
That is under challenge.
Next.
Item 37.
Mr. Behra Vijay Kumar Behra. What is the prayer here? As to why the rejection of the claim of the petitioner for payment of revised estimate amount is going to real consistent. Is my response due to construction of land. Revised estimate. रिजेक्शन पेज 31 में जो ऑर्डर है annexure 5 reasons for rejection होची that Bhile so and so was notified for acquisition of land under so and so according to clause C of Odisha rehabilitation so and so cut-off date for the purpose of compensation shall be the date on which notification declaring so and so. Okay, under the provision of for village, the cut-off date is so and so for partially affected families after verification of the records and documents submitted by so and so. Meena Dandasana. It is ascertained that as per Aadhaar card, the date of birth of so and so, hence both of the petitioners are born after the cut-off date, 14/7/2000. Disability certificate submitted as proof of are issued after the cut-off date. In view of the already applications for claiming rehabilitation also. Yes, you are there.
Item 48.
I mean, please, my lord. My lord, in this matter, my lord, as per the annexure 11, my lord, earlier order was passed on the lease granted to the granted to the grandfather of the petitioners. As attending the war in the Indochina war.
The earlier order
Earlier order-
facing,
my lord.
there you said that a representation is pending
My lord.
by the annexure 9, page 44, 45, 46.
My lord.
And
My
it
lord.
may be directed to be considered within a stipulated time.
My
This
lord.
order was passed on 14/7/23.
My lord.
Then what happened?
My lord, in the meantime, the petitioner of the earlier writ petition was died. Living behind these petitioners.
Again, you have made it.
My lord, again, I am the legal. My lord. The legal heirs and
14.
the author representation ଦେଇଛନ୍ତି
my lord.
କେବେ ଦେଇଲେ ନାଇଁ ଆଦେରେ ପଡିନି 20/6/2024 representation date
Application.
petition
Petition.
petition
My
ଦେଇଛନ୍ତି
lord.
ତା ତଳେ ଡେଟ୍ ବ୍ଲାଙ୍କ ପଡିଛି ତ ତାହେଲେ 20/6 ପାରାଇଟ୍ 20/6/2024 କୋଉ ପାରାଗ୍ରାଫରେ ମେନସନ କରିଛି
14 para 18
Annexure 14.
18
Of the writ petition.
of the read petition.
petition para 18 ପଡିଯାଇଛି ଏପର୍ଯ୍ୟନ୍ତ କିଛି ରେସ୍ପନ୍ସ ପାଇନାହାନ୍ତି
No, my lord. No response is there.
Parent council this writ petition has been filed by so and so with a prayer for issuance of ROR in their favor. The same lease which has already been allotted in favor of the grandfather of the petitioners under annexure 2 under Jawan lease allotted participated in Indochina War. The Land Council for the petitioner submits that earlier with this man, Sarathun
Suratan, my lord.
Sikhi,
The daughter of the
Legal hair.
daughter of the this is
the daughter of the deceased namely so and so.
MD Gulzara. MD Gulzara had. MD Gulzara had, my lord.
Approach this court by filing writ petition number WPC number so and so, which was disposed of as for order dated 14/7/2023, and this court directed the representation under annexure 9 to the said writ petition to be disposed of by the opposite party number 2.
When earlier was 2, my lord.
Opposite party number. See, earlier কথা কହୁଛୁ opposite party number 2 case କିଏ ଥିଲେ?
Secretary Home Department.
Opposite party number 2, the Secretary Home Department, to dispose of, to consider the representation and pass appropriate order in accordance with law within a period of 3 months from the date of production of the certified copy of the order. The Land Council submits that in the meantime, Sarathun Deva has died and the petitioners are legal there, and they have submitted a phrase representation by annexure 40 on
20
2024 and for grant of for issuance of ROR in connection with the lease case number 55 of 2011, but no communication has been received from the opposite party. Now, kagu deyithile eta or secretary
Home Department and number 4 and 2
or 2 and 4 for them.
my lord.
And the same may be directed to be disposed of. Then in order for the within 3 months from the date of production of these bonds, it is to be disposed of and order to be communicated to the petitioner within 15 days thereafter. Yes.
Item 59.
Mr. Das, Ashwini Kumar Das. Disposal of representation. Annexure 3. Annexure 3 to be disposed of. Yes.
Item 51.
51. My lord.
Petitioner challenging the order stated. Order under annexure 11, my lord, page 43, rejecting the grievance of allotment of land to the petitioner institution, my lord. Earlier petitioner filed a writ petition which was disposed of with a direction to the opposite party to consider his representation, my lord. Representation was considered and which was rejected on by order dated 28/8/2000.
Just come to the operative part of the order.
My lord.
That is perhaps 45 or third paragraph question. Second paragraph lekha hai and where are the representation of the petitioner so and so wala tapre.
My lord.
Please read it.
Second, my lord, may I read?
And where are the GA and PG department is the custodian?
My lord. In which the representation of petitioner was disposed of in pursuant to order passed by the Honorable Court WPC number 21474.
Paragraph question. Paragraph question.
Your representation for allotment land is enclosed by the.
And where is the GA and PG department in the custodian?
Next paragraph. 45 page.
Yes, 45 or third.
And where is the G and PG department in custodian of the government land in the capital city as per the Odisha government land rule of the business. The order was issued by revenue not applicable in the respect of the land stipulated in the capital city. Further, those orders are applicable in respect of government educational institution. The petitioner is not a government educational institution. It is run by the private individual. The institution has enclosed the government land. My lord, in this circumstance,
and whereas on verification,
whereas on verification or record, it is seen that the plot number 486 area 1297 dismil of Kisamo Bharabari second and plot number 1775 area of 2.940 dismil Kisamo Bharabari 2 stand recorded in the name of General Administration Department under Khata number 1427. And whereas the suit land is available government land situated in the heart of the capital city, the land cannot be used for various development purpose of the state capital. Now the prayer of the petitioner allotment of the land in favor of the petitioner's school is rejected.
Yes, so
my lord, petitioner is running his school since 96, my lord. Thereafter, he has applied for lease. Under annexure 3, my lord. Under annexure 4 for allotment of land, my lord. Thereafter, my lord, during the pendency of lease application, he found that this institution are allotted to some other institution. that is Annexure 5. He has obtained under RTA Act and found that Saraswati Sishu Mandir, they are going to allow Saraswati Sishu Mandir, my lord. For that, he objected, and after objection, my lord, that was not been considered. My lord, Annexure 5, my lord. In the similar circumstances, my lord, private institutions are allotted land free of premium or by concession of the payment, my lord. That is under Annexure 6, page 29. My lord, basing on the similar institution, my lord, the petitioner, being a educational institution, approached before the opposite party for granting of lease, my lord. Thereafter, my lord, government taken a policy decision at that time, 10% and 50% subject to payment of concession, they are given land, my lord. My lord, I am praying earlier for free of premium, but now he is praying for concessional premium, my lord. My lord, since lease application has not been considered, my lord, the lordship may direct my lease application be considered with
consider पर है कि reject है
reject होला पर आप
lease application has not been considered 96, which is pending, my lord.
ଏଇଟା representation
is considered and rejected.
lease application କାହିଁ ଆପଣ
Annexure 4, my lord.
97 or
97 is pending ଅଛି, my lord. And this institution now obtaining permission from the educational appellation and permission and running the schools.
এটা বুঝিলে for 97 would application pending ଅଛି lease application.
Lordship kindly have a glance to that order. He is relying on the notification. That notification is not meant for the private institution. That is very clear in our order.
But they have allotted institution under Annexure 6, my lord. That is private institution are there.
They made it very clear that notification is not first meant for the private institution.
In spite of notification, if you are allotting to the private institution and the list has been given there, so that is his grievance. Why are you discriminating one institution from the other? What is he is ready to pay that premium, of course, at concessional rate. So the question is that, and he is running that institution since 1996. And so in the meantime, so many years have passed. So if for 30 years a man is running the institution on a particular plot, and you are allowing such type of thing in respect of other private institution, why the petitioner has been deprived? So that is why he is dead.
But I would think
से ଗୋଟେ list ପୁରା ଲମ୍ବା
list ଦେଇଛନ୍ତି ଯୋଉଟା କି 97 ରୁ ଧରିକି 2006 ପର୍ଯ୍ୟନ୍ତ ହେଇଛି. So his matter is pending since 1997.
his representation being repeatedly rejected. When he has given representation, it was always rejected.
Earlier 2-3 representation
case ଟା ଆପଣ ଆପଣ ଲିଜ କେସ୍ ଟା ଯୋଉଟା ପେଣ୍ଡିଂ ଅଛି Annexure 4
ତାକୁ dispose
ଯଦି ଆମେ ଲେଖି ଦଉଛୁ ନହେଲେ Annexure pending ଥିବ if that is to be disposed. This writ petition has been filed challenging the later dated 28/8/2024 passed by whom?
Passed by
opposite party number.
One is the chief secretary, my lord, GA department.
Opposite party number 1. In rejecting the representation filed by the petitioner for allotment of the land in favor of the school, it appears that earlier the petitioner approached this court in WPC number 16001 of 2013, which was rejected as per order dated representative of so and so, 14/3/2024 of the General Administration and Public Revenue. ତାପରେ ଆଉଥରେ read ଗୋଟେ
ଆଉଥରେ read
ତା ନମ୍ବରଟା କେତେ?
my lord,
3DCH5.
ଆଚ୍ଛା ନାଇଁ ସେଟା ଆଗ
read petition, my lord.
then the petitioner filed another writ petition that
12046
1046 of 2024
which was disposed of in 2000
disposed of on 14/5/2024, and this court directed the opposite party number 1 to consider the representation filed by the petitioner and to pass appropriate order as early as possible within a period of 3 months from the date of production of the certified copy of the order. The opposite party number 1, considering the pursuance of the order passed by this court, consider the representation and held as follows. Quote from page number 45 ରୁ ଅଛି ସେଟା ହଉଛି and whereas the GA and PG department ସେଇଠୁ ନେଇଯିବେ is rejected ପର୍ଯ୍ୟନ୍ତ ହେଲା. The London Council for the petitioner submits that the lease application of the petitioner by annexure 4 is pending with the kaha pakhre pending achi
pending before the GA department director
before the director so and so litigant. ତାଙ୍କୁ ପାର୍ଟି କଲେନି କେମିତି? ଯାହା ପାଖରେ ପେଣ୍ଡିଂ ଅଛି ତାକୁ ପାର୍ଟିଟେ କରିବା କଥା ନୁହେଁ, ତାଙ୍କୁ ଡାଇରେକ୍ସନ ଦିଆଯିବ କେମିତି? ଡାଇରେକ୍ଟରେଟ so and so ଲେଖିଛନ୍ତି ଉପରଟା ହେଲା. And similarly situated private organization has been favored with lease, which should be evident from annexure 6, and therefore the direction may be issued to the government to consider the annexure 4, keeping in view the that similarly situated institution have got the relief without expressing any opinion on the merits of the application for allotment of land submitted under annexure 4. We dispose of the petition that if annexure 4 is still pending with the authority, same shall be disposed of within a period of 3 months from the date of production of the certified copy of the order, and the order be communicated to the petitioner within 15 days thereafter. Accordingly, the petition is disposed of. Yes, next.
Item 42.
Originals prescribed fund is pending before item number 3.
Annexure 2.
Yes, my lord.
That is
Annexure 2 to be disposed of. Yes, next.
Item 43.
Yes.
Please, yes, my lord. Can be allowed to appear virtually, my lords.
Yes.
Here under challenge is annexure 11 at page 55, my lords. Cancelling my allotment of lease plots, IDCO lease plots, my lord, 68 and 68A. 2 plots, my lord, bears relevance. For the reason for the cancellation is that I have been allegedly unauthorizedly encroaching an adjoining plot, which is 68B, and constructed a building of my own. That seems to be the only ground, my lord. My sole bone of contention, in fact, is if your lordship takes page 21, that is clause 16 of the lease deed. All I'm saying is, my lord, that there is no violation cited with respect to the lease deed. Me having encroached an adjoining land, and that adjoining land, my lord, in fact, was recommended to be settled in my favor, leased out in my favor by the DIC. So I have been using that land for parking purpose and loading, unloading. If your lordship sees clause 16, it lays down the procedure for termination. Your lordship says clause 16, my lords, at page 21.
Yes.
Lordship. May I place it, my lords?
Yes, yes.
If the due of the lessor hereby reserved or any part thereof shall at any time being arrears and unpaid for 6 calendar months next after the date on which the same shall have become due, whether the same shall have been lawfully demanded or is relevant, my lords, or if there is a breach or non-observance by the lessee of any of the conditions and covenants herein contained, and the lessee fails to remedy the breach within 6 months of notice in writing given by the lessor, or becomes insolvent, such and such, the termination will be following. So, my lord, important is this curing period of 6 months to be provided to the lessee to remedy that breach cited. My lord, the sole reason being, under the lease deed, covenants of the lease deed, it allows the lessee to undertake certain developments, constructions, permanent constructions for usage of the particular lease land for the purpose demarcated therein. And therefore, to ensure continuity and in fact prevent the lessee from such arbitrary action, my lords, in my humble submission, this is a mandatory curing period provision provided which shall precede the termination, my lords. This having not been done,
This annexure 11 indicates that so-cause notice was issued to you, two so-cause notice, and you have also given your reply to that.
I have given my reply to that.
Yes, and after considering the same, they found it not to be satisfactory.
Lordship.
And accordingly, the allotment was cancelled.
Lordship.
So
there was in fact a lease. The lease was cancelled.
Yeah.
All I'm saying is the relation inter se parties was governed by the terms and conditions of the lease deed, my lords. So in case in fact there was a breach, even if it is accepted for a moment.
No, in what way they say that there has been contravention?
They only say that I am unauthorizedly occupying an adjoining plot of my lease.
Where is that? Where is that?
Lordship takes page 55 of the impugned cancellation order.
No, from that it is not clear actually. In reference to, please read it out.
Yes.
That from the beginning.
Lordship, in reference to the subject cited above, we wish to inform you that you have been allotted IDCO plot 68 and 68A with an area measuring acre 0.352 at Industrial Estate Jagatpur New by transfer letter number such and such, letter dated such and such, and letter such and such for manufacturing of cattle feed. Okay. Now it appears that you have contravened the terms and conditions of the allotment, for which this office issued two so-cause notices to you, vide the so-cause letter referenced above on the following grounds. This ground number one is...
Ground is that you have unauthorizedly encroached over 68 by B.
68 by B.
That is
the only ground, my lord.
Even if it is a building on your own, on that part.
Lordship. So I'm using it.
That is the violation. Then you say that clause 18 of that 16 of the lease deed.
16, my lord, and in fact 18 also bears relevance because 18 is the corresponding provision which says that in case the lessee wants to terminate, the lessee also will have to give a 6 months notice. At the behest.
But in this case, according to you, 16 is applicable.
Lordship.
And 16 says, or part thereof so and so, if the lesser there were, if the due, it is the due katha kuchi. Due katha.
Due pore, my lords, there is an or.
Or if there is any breach of non-observance or by the lessee of any of the condition, so and so, lessee fails to remedy the breach within 6 months of the notice in writing given so and so, and becomes so and so, so and so, the agreement will be deemed to have been terminated.
Did you make any endeavor to ensure the authority that you are going to demolish that pursuant to the notice? Because you have not been allotted under the lease, the 68 beta.
Lordship.
So did you, after this notice, did you make any endeavor to assure the authority that you are going to demolish it?
No, my lord, in fact, I have not in my show cause notice. What I have reflected is that I, in fact, I have expressed my intention to take over 68B.
That is different. For that, you have to go for a separate lease or allotment or anything.
Yes. I
But
have
prima facie, as it is seen, that you have encroached upon having taken the allotment for 68 and 68A.
Right.
You have encroached upon and even constructed a building over 68B.
That is the
the
ground.
difference.
That
So
is the
unless you make a assurance before the authority that you will demolish it, why should they allot it? You encroach upon it and then you ask that you allot it.
Encroach, construct a building and then asking, this is not the way.
Yes.
Lordship, my lord, in fact, what had happened is in the year 2010, DIC had recommended that 68B be leased out to me. So pursuant to
Who has
that,
recommended?
DIC, my lord, District Industry Center, Cuttack.
But district indices is recommending authority. But ITCO is the authority over the land and the said.
That single window system was not there, which now IPCOL exercises.
Whatever.
So DIC,
Who is appealing for the ITCO?
ITCO.
They
have their panel law.
ଘର ବିଲ୍ଡିଂ କରିସାରିଲେଣି ଯଦି ଦେଇ ହବ ତାଙ୍କୁ
ପ୍ରିମିୟମ କଣ
ଦେଇକି ତାଙ୍କୁ issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. And counsel for the state accepts notice on behalf of 1 and 5 and requisites for issuance of notice on 2 to 4 and 6 shall be filed by day after tomorrow. Put up this matter after 4 weeks further.
No coercive, my lords.
IA number so and so, no coercive. Steps shall be taken in pursuance to the order under annexure 11 till next day. Yes.
Grateful, my lord. Grateful.
And Mr. Abhishek Das, what's the motive?
Item 44.
May I please your lordship, please? That is the covered matter of Narottama Rathan versus State of Orissa.
Dispose of yes, next.
Lakshmi Sharma Jutta Kotli 45.
Item 46.
45 for and after. No, first hour mention.
Item 46.
Yes. My lord, in this case, I am coming from the Honorable Court to challenging the order of the by the Annexure 1. So the opposite party bank has a lock and key the residential house along with the cow shed. My lord, under section of the Securitization Act, the amount is pending 57,42,000. 57,42,000.
13.4
13 पर सिक्युरिटेशन 13.4 दीजिए
इनिशियल लेनी तो
हम कलेक्टर को ग्रीवेंस लेटर देचे अनेक्सर माइनर काइंडली सी
कौन एटा पोजीशन टा कोन दा
पोजीशन से देचे लॉक हमें मेडिकल रेप्स से लॉक कर देचे
फिजिकल पोजीशन आप बर्तन को ये ठीक है रीड पे अपन यू आर टू चैलेंज दैट ऑर्डर
चल इन द रेजिडेंशियल हाउस ओनली टू सम डिपॉजिटेड लॉक एंड की
No, the position against 14, how a writ petition is made.
The statute also this Honorable Court has ample power.
Ample power after 38.
The only residential house, my lord. The lock and key is the contrary bank. In the pendants of the collector order, my lord, under 39 Annex 9, we have given collector to the brother to submit my grievance. Also, collector has passed an order. Instead of order of the collector, they have the lock and key. And I and along with my wife was under treatment before the Capital Hospital, Bhubaneswar. That I have filed also medical certificate. I have filed on 27.
There are a number of decisions.
Yes. In the meantime, we give me protection for him.
No protection. Petition is not maintainable. How can we pass any interim order in that? The petitioner has challenged this one, so alternatively, we are not inclined to
Given opportunity to deposit some amount, lock and key खोल दें.
Simply you go to there and face the matter that
I will go to that forum, but in the meantime.
no meantime. You are appealing for the Bank of Baroda.
Yes.
Bank of Baroda.
Item 47.
Adjournment after vacation, my lord.
Plan counsel for the petitioner seeks for an adjournment. Yes. After
Item 48.
Item 14, I pray for after vacation, my lord. I'm from virtual mode, my lord. Item 14, I pray for after vacation.
all right, after the holidays.
Item 50.
In this case, the petitioner challenges the inaction of the bank in not considering my representation.
What is your representation?
That's my representation is at Annexure 3 and Annexure 4.
Annexure 4.
That's
Annexure 4 टा होची 39/2024. ଏବେ ଦେଇକିନି ଇଆଡେ ଫାଇଲ କରିଦେଲେ କି
no,
representation?
that's my first representation is 29/8/2022. That's in the meantime, the bank has given a letter.
Representation to be disposed of. Yes.
Miller's bank has given a letter stating that if we pay the amount the bank, no coercive action shall be taken. That's I am filing.
We are directing representation to be disposed of. That's all.
Let's say I am filing a memo.
13.4 भी ही सर इसे 13.4 ही सर
13.4.
Auction sale notice. By
then we are
not entered.
No.
Not entered.
Sorry.
Let's say I am filing a memo.
ऑक्शन सेल 25/22 में ହେଇଗଲା नी
Yes, the auction first failed.
जहाँ भी हो
But in the meantime, bank had given the letter stating that if we pay the amount, no coercive action shall be taken.
What is that?
Let's say I am filing a memo.
କେବେ
Let's say
memo नहीं बैंक जोटा ଦେଇଛି କାଇଁ
Let's say ଏଥିରେ annex କରିକି ଦଉଛି.
କାଇଁ ନା ଏଇଠି କାଇଁ
Let's say 5 ତାରିଖରେ ଦେଇଛନ୍ତି ପରଦିନ ଶନିବାର ଦେଲେ.
କଣ ଦେଲେ
ସେ ଗୋଟେ ଲେଟର ଦେଲେ ସେଥିରେ ଦେଲେ କି if we pay the outstanding amount, there is no coercive
pay.
That objection repeaton file କଲା ପରେ ସେମାନେ ଦେଇଛନ୍ତି.
ଓହୋ ଠିକ ଅଛି ତାହେଲେ ଭଲ
The memo may kindly take a record.
Land counsel for the petitioner, however, submits that he has received. The petitioner has received a letter from the bank, Union Bank of India, for payment of some amount. Where is that letter?
Let's say 5/10/24.
I 2024. If you seen the
if you pay the amount
receipt from the authorized officer, Union Bank of India. Wherein, even though it is mentioned, wherein it is mentioned that if the petitioner pays the amount due to the bank, along with the subsequent interest, costs, charges, and expenses incurred by the bank before the date of publication of the sale notice, no further action shall be taken
for sale of the
for the sale of property, and he can redeem his property as stipulated in 38 of this month. This is letter dated OC 3/10/2020. The land counsel for the petitioner submits that the petitioner is ready and willing to pay the dues of the bank along with interest, costs, etc.
If any such notices been issued by the bank, if any such notice has been issued, then to bank to verify if any such notices.
If if any such notices have been issued by the bank opposite party number 1, on 3/10/2024, and the petitioner complies the direction we want. So it is up to the bank to consider the same as per the banking regulations.
That's my another product. I have filed an IA.
I is also disposed of. Yes, no.
Let's, on any suitable terms and conditions, they locked my house. That may be unlocked on.
No.
ସେ ତ କହିଛନ୍ତି ଦେଲେ ଦେବେ ଆଉ
Yes, next. Pass over.
Possible item number 36.
This matter is found for the first time.
ଆପଣ ନାଁ ଲେଖି ଦଉଛୁ ହାର୍ଡ କୋର୍ଟ କାହା ନାଁ ଲେଖ ନାଁ ଲେଖି one so for the bank
Well, the petitioner bank challenges
which one?
the order of the collector Jajpur, which is at annexation.
that is
Yes.
The petitioner bank challenges the order of the collector Jajpur, which is at annexation 9, running page 54, wherein he has refused to cooperate with us for giving possession of the mortgage properties, which have already, my lords, the borrower had filed proceedings before the DRT. DRT has also, my lords, dismissed his application. We filed an application under section 14 of the Act. Your lordship comes to the impugned order. Perused application of the authorized officer of the Urban Cooperative Bank, Jajpur, along with other documents in which he has paid the collector under section 14 of SARFAESI Act for providing all assistance like police force and magistrate to the authorized officer to take possession of these secured assets below of the borrower due to non-payment of loan dues. On verification, authorized officer has also not filed any acknowledgement receipt of possession notice under 3(4) of the SARFAESI Act.
13 for hours.
14 hours.
Yeah.
13 for hours.
13 for hours.
4. After adopting all procedure for taking over possession of secured assets, the bank sold the secured property to the private party through auction sale, and after auction sale, the loanee filed an application before the DRT Cuttack, and the DRT dismissed the same dated 31/1/24. The secured creditor has not filed requisite documents like served copy of demand notice under 13(2) and 13(4) possession notice of SARFAESI Act. So due condition as provided under section 14 of SARFAESI Act has not been maintained by the secured creditor during filing of the request letters. Besides, prior filing of the SARFAESI application, the bank authority has sold the secured property to private person. Now the property is in the name of the private person and he is the owner of the property. As provided under section 14 of SARFAESI Act, the collector is the competent authority to provide magistrate and police to the authorized bank for taking over possession of the secured property, but not to a private person, as the property has already been owned by him through auction purchase.
Yes.
This is his reasoning, my lords. If your lordship sees section 14, lordship gets it.
What is the status of the property now?
Already auctioned possession, my lords. We have sold it to the auction purchaser, but we have not been able to take possession, which we wanted to do under the provision by due process of law. That has not been accepted to or adhered to by the collector judge.
Just read that of section 14.
Section 14, my lords, I'm placing. Where the possession of any secured asset is required to be taken by the secured creditor, or if any of the secured asset is required to be sold or transferred by the secured creditor under the provisions of the Act, the secured creditor may, for the purpose of taking possession or control of any such secured asset, request in writing the Chief Metropolitan Magistrate or the District Magistrate within whose jurisdiction any such secured asset or other documents relating thereto may be situated or found, to take possession thereof, and the Chief Metropolitan Magistrate, or as the case may be,
the district magistrate shall, on such request being made to him, take possession of such asset and documents relating thereto and forward such asset and documents to the secured creditor, provided that any application by the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer of the secured creditor, declaring that the aggregate amount of financial assistance granted and the total claim of the bank as on the date of filing the application, the borrower has created security interest over various properties and that the bank or financial institution is holding a valid and subsisting security interest over such properties, and the claim of the bank or financial institution is within the limitation period. The borrower has created security interest over various properties, giving the details of properties referred to in subclause 2 above.
1 to 9.
1 to 9.
This is to comply.
And we have given such an affidavit.
Where is that?
Dear my lords, the borrower has committed default in repayment of the financial assistance granted aggregating the specified amount. Consequent upon such default in repay of the financial assistance, the account of the borrower has not been classified as has been classified as a non-performing asset, affirming that the period of 60 days.
This is one of the requirements.
These are the requirements,
No, just read that.
Yes, affirming that the period of 60 days notice as required by the provisions of subsection 2 or section 13 demanding payment of the defaulted financial assistance has been served on the borrower. The objection or representation in reply to the notice received from the borrower has been considered by the secured creditor, and reasons for non-acceptance of such objection or representation had been communicated by the borrower. The borrower has not made any repayment of the financial assistance in spite of the above notice, and the authorized officer is therefore entitled to take possession of the secured assets under the provisions of subsection 4 of section 13 read with section 14 of the Principal Act, that the provisions of this act and the rules made thereunder have been complied with. These are the conditions.
Yes.
Now, your lordship sees the order of the DRT.
You have not filed these two vital documents that you have.
Filed, my lordship.
No.
List of documents is there.
Where is that? He has said that the authorized officer has not filed the acknowledgement of receipt of demand. Where is your application? Let us see.
Your lordship may kindly see Annexure 8. It starts.
Yes.
Page 48, Annexure 8.
Yes.
List of documents submitted before DM for seeking permission for physical possession of L&B.
ଆପଣ ଦେଖନ୍ତୁ number 3 को पढ़े आसंतु आपण खाली demand notice टा देइचंती. What it requires, the demand notice must have been served on him. So that he says that there should be an acknowledgement or receipt of the demand notice. Where is that?
Malak, there is page 22. Check. 20. 24. Department of Post. It has दिया है चित्तकू. 26 रे आउथरे दिया है.
नहीं ये जो डॉक्यूमेंट गुड़ा को सी कहउचंती वांटिंग थिला बेली acknowledgement of demand public receipt of demand notice the 13 रो से डॉक्यूमेंट आपनकर जो लिस्ट ता फर्निश करचंती सेटा नाही. जदि अछि बेली आपन कहउचंती हमकु देखांतु, जदि नाही तो आउथरे देई दियंतु से एप्लीकेशन गुड़ा.
We will supply all necessary lordships में other documents which are found wanted.
Yes. Lekhondu, the petitioner has so and so has challenged the order dated 18/7/2024 passed by the opposite party number 1, collector and district magistrate Jajpur, dated annexure 9 in miscase number 10 of 2024 in rejecting the prayer for passing any order under section 14 of the Surface Act 2002. It appears that a petition, an application was filed by the petitioner under section 14 so and so for providing all assistance like police force and magistrate to the authorized officer to take possession of the scheduled mortgage properties, that is, এটা লিখে দেবে পুরা once. On verification of the documents filed by the petitioner, the opposite party number one observed as follows, quote कर देवे so and so, है ना? The land and counsel for the petitioner drew the attention of this court to Annexure 8, which is the list of documents submitted before the opposite party number one, seeking permission for physical possession of L&B of Dr. Mahapatra Kalidas Jayasingh. However, from the said list, it appears that the documents which you are wanting, as mentioned in Annexure 9, in fact, is not available in the list. Mr. Milan Kangal and senior advocate submits that the petitioner may be permitted to file a fresh application under Section 14 of the Surface Area Act, giving all the required documents, and the same may be considered in accordance with law afresh without being influenced by the earlier rejection order. We are inclined to the submission of this one. So, Mr. Kanungo, if the petitioner files a fresh application within a period of 2 weeks, with all the required documents, the same shall be considered by the opposite party number one afresh within the
Or
time
10 working days. Can I
within 10 working days. Within 10 working days, the same shall be considered once in that within the period stipulated as per the said section, and the result thereof shall be communicated to unto Swami. Disposal. Okay.
Item 57.
In fact, the Supreme Court says it is only a ministerial task.
No, ଆପଣ ସେ
compliance ଟା ଦରକାର
13 ରୁ ଖାଲି ଗୋଟେ notice ହେଇଛନ୍ତି,
Notice.
ଯଦି ସେଟା ତା ଉପରେ serve ହେଇନି ତାହେଲେ it would be that he is not
Infructuous
aware about.
notice.
So that is why
Infructuous.
that what is the proof that it has been served?
DRT ର order ଟା ଦେଇଛୁ, DRT has discussed everything. DRT ର order ଟା
Better
ଦେଇଛୁ।
if the documents are
ଦେଇଦେବୁ authorized to buy peace ଆଜ୍ଞା।
Yes.
Item 57.
Yes.
Your Lordship, this one of the Lordship challenging rejection of the claim for payment of a rehabilitation assistance.
7.
That is
Right.
being physically handicapped, physically challenged.
What is your prayer in this?
My application, my claim rejected by the special LO on the ground that under Annexure 5 running 31. Running page 31, Annexure 5, paragraph number 4.
So how do you meet it?
Not
a cut-off date fix up.
Cut-off date that wrongly mentioned that the 14/7/2000, but the government decided running page 2, Annexure 20, running page 22, Annexure 2. Extension of evacuation year or cut-off date is 1/1/2015.
You file a representation again.
Then you file it.
Thereafter, after the decision of the government, the collector has verified my document and submitted before the director for payment running page 29, Annexure 4.
Yes.
Annexure 4, my name is, I am the brother and sister, only daughter and only son.
Okay, then what happened?
Thereafter rejected my application, Your Lordship. Rejected kale sei ground re je semane ei cut off date re কিন্তু cut off date টা decide ହେଲା 1/1/2014 ସେ କହୁଛନ୍ତି 2000 cut off date at the time of transaction acquisition.
Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of all the opposite parties. Opposite party extra copies of this also be served and matter be listed after the 4 weeks per counter if any be filed in the meantime. Yes.
Sir,
I want to mention, my lord, item number 26. I am on behalf of Mr. Sanjeev Swai for Union of India. Today I am filing my appearance memo. My name is
26 time after puja holidays.
Yes, my lord. No issue. Yeah. Mr. Sanjeev Swai, Senior Panel Counsel for Government of India.
हाँ दियंतु ए 26 के डिक्टेशन नहीं चलती हम खाली कहबे ए जो यूनियन ऑफ इंडिया पई संजीव स्वाई फाइल करले
नंबर 1 to 3 for railway.
नंबर 1 to 3 सेटा खाली नोट डाउन कर दो
Obligement.
संजीव
List item number 1.
Also couldn't have
last time
is not first thing. Why to keep
on instruction yes yes no Asuri how देखियो
Item number 2.
May I please, your lordship?
At the last occasion, your lordship called for the study certificate of the present appellant petitioner.
appellant number 1.
Yes, my lord. I'm checking for bail. My lord, the petitioner has been convicted under section 302, 307, 341, and 34 of IPC.
This is your first application or earlier rejected?
No, my lord. Earlier one bail application of the appellant has been rejected on dated 23/6/2016. But miscase number 3.
23/6/2016.
Yes, my lord.
Rejected.
Yes.
Any other application?
No, my lord.
You have never been released on interim bail.
Yeah, no, my lord.
So that is another appellant is there. Appellant number 2.
Katram Purti.
He has been granted bail.
Yes, my lord, by your lordships. On the same footing, my lord.
He has been released on bail.
2 and 4 allowed, bail allowed.
Only 1 and 3.
No, this application is for appellant number 1.
1. All are released on bail except 1 and 3.
Is there any difference between these two? This you said that 2 and 4 have been 2 and 4 have been released on bail. You said, Mr. Tripathi?
Yes, ma'am.
same role?
Same role na kaun hiche alga?
Same role. 1 and 2 are very similar.
Appellant number 1 and 2.
Similarly situated.
Similar.
Or the Learning Council for the petition, Learning Council for the states. The Learning Council for the petitioner, the state has produced the custody certificate of the petitioner. It was the appellant number 1, which indicates custody for 10 years, 11 months, and 19 days as on T10/2024. The custody certificate is taken under trial. The Learning Council for the petitioner submits that the petitioner is similarly situated like appellant number 2, namely Kottaram Purti alias Katia, who has been directed to be released on bail by order dated 30/10/2013 in IN number 2169 of 2023. And since paper book has not been prepared, there is no chance of early hearing of the appeal. Therefore, the bail application may be favorably considered. Learned counsel for the state on verification of the evidence or the judgment fairly submits that the petitioner is similarly situated like appellant number 2, considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, the release of the similarly situated or accused bracket appellant number 2 on bail, and absence of any chance of early hearing, we are inclined to release the petitioner on bail. Allow.
Deeply obliged, my lord. Item number 3.
May I please? In the last occasion, Lordship has called for the custody certificate. The petitioner was arrested on 31/1/2011. Now he is only custody for 13 years, 11 months, and some odd days.
Whether the bail application was earlier rejected?
No, no.
There was some quarrel between the petitioner and the.
My lord, what happened, my lord? The petitioner, his father, the mother, all of them, they went to the local market. In the local market, they consumed handia, my lord, on the relevant day. And they came back to the house. And there was a quarrel between the appellant and his wife.
Wife is the deceased.
No, wife is not the deceased. Father is the deceased.
Achha.
And there was a quarrel between the appellant and his wife. And during that quarrel, the father of the present appellant intervened.
And then you built a blow.
She is the eyewitness, my lord. She is the mother of the appellant, wife of the deceased, PW3. In the cross-examination part, she has also admitted that on the relevant day, both of them has consumed handia, and there was a quarrel. Cross-examination part
is due to injury to the brain.
Well, PW12 is the doctor, my Injury number 1 is fatal, as per the Planet Trial Court.
The trial court later PW12.
PW3 Lordship may kindly peruse me,
Lord.
Gula है हमरा
lacerated होगा बाकी brain fracture later.
Skull fracture, brain.
Cause of death is due to shock following severe hemorrhage and injury to the vital organ, that is
by blow of hard and blunt object.
Counsel for the petitioner and counsel for the state. Still and counsel for the petitioner. And counsel for the state has produced the custody certificate, which shows that as on 28/9/2024, the petitioner was in custody for 13 years, 11 months, and 26 days. The custody certificate is taken on the phone. The land counsel for the petitioner submits that the deceased was the father of the petitioner, and while the petitioner was quarreling with his wife, the father intervened and the petitioner is stated to have assaulted the father on his head by means of an iron rod. And as per the evidence of the doctor, bracket PW 12, the cause of death is due to shock following severe hemorrhage and injury to the vital organ, that is brain, which was caused by blow of some hard and blunt object. The land council subject that in view of the period of detention of the petitioner in judicial custody, and since paper book has not been prepared, there is no chance of early hearing of the appeal in the near future. The bail application of the petitioner may be favorably considered. Land counsel for the state opposed the prayer for bail and placed the evidence of PW3, who is an eyewitness to the occurrence and happens to be the mother of the appellant and widow of the deceased. Considering the submission made by the land counsel for the respective parties, the background of the case, the surrounding circumstances under which the offense stated to have taken place, the period of detention of the petitioner in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed. Bless.
Number 4. Madam, can be taken over after vacation. Kindly taken over after vacation.
Land counsel for the appellant 6 per night with this matter after ensuing Durga Puja holidays.
Number 5.
Made
Item 6.
May I please worship? Lord, on the basis of prisoner's petition, I'm appearing in this case.
Yes.
Is to be accepted, but says somebody, some Biswajit Naik is there.
You have filed your Vinama.
Yes, my lord. Mr. Biswajit Naik and
Prisoner's petition regarding engagement of advocate Vishwajit Naik. Mr. Naik and his associates have filed Vinama, which is accepted. The names of other counsel except Mr. Vishwajit Naik and his associates shall not be reflected in the clause list. Yes, what do you want?
my lord, I'm providing a copy of the position to the
Learned counsel for the appellant supplied the deposition copies to the learned counsel for the state and court, who took some time to go through the same put of this matter after ensuing puja holiday for consideration of the interim applications. Yes.
Yes, my lord.
Item number 7.
May I please your lordship? Lordship may direct the court below to call for a report that whether the petitioner has appellant has surrendered or not.
The Mahapatil and counsel appearing for the appellant submit that he has no instruction whether the appellant, after appealing the interim bail, has surrendered in the court below or not. Let the registered judicial call for a report. Let the registry call for the report from the land lawyer court on this aspect. File be placed before the land registered judicial. Yes. After puja holidays.
Item number 8.
Item 8, my lord, in sub-item in JCRL 25 of 2018, they have filed an IA number 127 of 2024. That may come along with that, my lord. Bail pay file for appellant number 2.
Without filing.
Yes, ma'am.
Either good or appellant number 2 fine.
Sita, your lordship instructed to that not press of that application.
JCRL 25 of 2000.
Yes, ma'am.
The IA number 64 of 2018. There is an application for bail of appellant number 2. The Learned Counsel for the appellant number 2 does not want to press this application. Accordingly, it was disposed of as not pressed. Learned Counsel out of a year ago. IA for it a main application letter. It is submitted that another interim application for bail of appellant number 2 has been filed, which has been numbered IA number
127 of 2024.
127 of 2024. Copy has been served on the learned.
In the office, I will serve another.
Let a copy of the interim application be served on the learned counsel for this date. List this matter after ensuing with the holidays. Yes.
Number 9.
Raghunath Das Mahapatra has been available. Schedule the prisoner petition at Class B for engagement of advocate Raghunath Das Mahapatra in place of the previously engaged counsel. Mr. Mahapatra has filed the nominee, which is accepted. The names of the other counsel except Mr. Raghunath Das Mahapatra and his associates shall not be reflected in the clause list of the holidays for consideration of the interim application for bail. Yes.
Number 10.
May I proceed? Sure. IA complaint on last occasion, a report was called for regarding the period of detention of the present appellant. He is inside custody since 31/10/2015.
So he was released on bail for some time.
Parole or not? Not.
I mean, pardon, Lordship, I am appearing, in this case, I am appearing for the informant.
What about his conduct, Mr.
That is not.
Oh, any instruction you have got about his conduct during interim bail?
So far as instruction I have collected, they have left out the village from the date of incident.
You are appearing for the informant.
Informant.
So you obtain that conduct. Yes. That's one. Mr. Vijay Kumar
Misra.
Misra.
Yes.
Missing on lekha
Misra.
MISHRA. Missi lekichan.
Misra. MSHRA.
Mr. and his associates supply power for the informant, which is taken under court. As per the order dated 18/9/2024, the London Council for the state has produced the custody certificate of the appellant, which indicates that as on 23/9/2024, is in judicial custody for 9 years, 7 months, 18 days. The custody certificate is taken on record. Our Land Council for the state seeks some more time to obtain instruction regarding the conduct of the petitioner during the interim bail period. Put up this matter after the ensuing Durga Puja holidays. Indicating the name of the Land Council for the informant.
Number 11.
Criminal appeal sub-item number 2, criminal appeal 177 of 22. In this case, your lordship directed me to file a comprehensive affidavit, and that has been filed. In the comprehensive affidavit, your lordship, I have taken instruction, and it has been in 2011, my lord. There are 2 criminal cases. Item 11, sub-item criminal appeal 177 of 22.
Both the cases are pending.
Pending. Since 2011, it is pending because this appellant is in jail since 6 years, and the trial court was Noaigad was transferred Saranpur. Noaigad fort, my lord, in Noaigad it was pending. New court was opened, so the cases were transferred. For that reason, the judgment declared.
Your bail application was earlier rejected.
No, my lord. Bail application has not been rejected.
Paperwork are, my lord, already prepared. Twice it was heard by coordinate bench, coordinate bench, and it was decided to for hearing. So bail application was not rejected, but coordinate bench, my lord, not inclined to.
You are for the informant.
Yes,
that's only one. So what is the case?
Yes, my lord. In a broad daylight, my lord, they have assaulted and 17 injuries.
8 injuries.
Only 8 injuries.
8 injuries.
Eyewitnesses are there.
Yes, 1, 5 and 9. Sorry, 12. I am 12. And their version is totally contradicted
to their earlier version, which was also being
Nine
confronted.
persons committed murder of Babuli alias Nakula Bantho in a brutal manner by means of deadly weapons like sword, farsa, jali knife. Judgment ର କୋଉ page ରେ ଅଛି ଇଏ ଯୋଉ discussion ହେଇଛି injury ଗୁଡାକ? ହଁ ଏଇଠି ଅଛି ଆଉ 100 medical officer 8 injuries were found. Vital part head, eye, critical lesion, occipital bones, multiple injuries on the head of the deceased also, parts of
Left eye was removed.
Here's how criminal anticipation he filed a comprehensive affidavit in item number CRL number 177 of 2020. Comprehensive affidavit taken on record. Copy we served on the Lion Council for the state. The dispute of this matters. He would have ordered this matter along with CRL number so and so after the Puja holiday. But just to the hard mission on the top party Lion Council for the informal. Yes.
231 madam. That is to call for regarding my to say criminal appeal connected matter. Criminal appeal 231 of 2022 madam. The report was called for that whether during continuance of that entry bail whether any misconduct has been shown.
Misconduct custody certificate CM
Yes. In the same case, my lord, criminal appeal 178.
Yes, next.
Lordship CRL 215 of 22. On the last occasion, Lordship has directed to state court.
Yes, next. Item number 12.
Item 12. My privilege. We have filed an interim application for interim bail in respect of appellant number 6, Lordship. On the ground that the mother was suffering from cholelithiasis and criticis, for which the doctor advised her for surgery of removal of two calculus measuring up to 8 mm, Lordship. And
happened. What is your instruction?
He has filed no direct.
You are for the informer. So you obtain instruction on that. IA number one. So this is an application for interim bail of appellant number 6 on the ground of mother self. Copy of the interim application has been served on the Land Council for the state to seek some time to obtain instruction on the interim application. Mr. Vijit Mahanti, Land Council for the informant is present after Puja holiday. Yes.
Item 13.
I beg pardon, my lord. On behalf of Mr. D.N. Patnaik, matter may kindly taken up after vacation.
Mention is made on behalf of Mr. D.N. Patnaik for adjournment put of this matters after Puja holidays.
Item 14.
Along with JCRL number 21 of 2022.
May I please?
Yeah.
My lord, last occasion, your lordship was pleased to sought for an report custody certificate. Order number 17, order number 2, dated 17/9/24.
Custody certificate of criminal antecedent.
Yeah.
1/4.
My lord, 1/4.
And no criminal case records. Certificate to the court. October 4 মাস 4 দিন। Offense no.
My lord.
Offense ଆଗରୁ ରିଜେକ୍ଟ ହେଇଥିଲା
I have no knowledge. I was engaged. Order sheet से किसी ने mention नहीं बड़ा first time पे आस्तिला जाबरे record में
302 ಇದೆ 302
offense under section 302 my lord.
The London Council for the State has produced the custody certificate, which is taken on record. He has also produced the certificate report from the inspector in charge of Malkangiri Model Police Station, dated 6/10/2024, which shows that there is no criminal antecedent against the petitioner. Both the documents are taken on record because this matter after ensuing the proper affidavit. Yes.
Item 15.
May I be permitted to appear through virtual mode, Your Lordship? On the on 17/9/2024, Lordship directed the London State Council to obtain instruction with regard to antecedent, so also the custody certificate.
Nine years, 7 months, 20 days. So whether your bail application was earlier rejected or it is the first one?
No, Your Lordship, this is the first time.
What is the allegation against you?
Lordship, conviction under section 302 IPC. In the present, the appellant was found with the deceased from the same room, from the place of occurrence. There is no eyewitness to the occurrence. Only a sole conviction is based on last seen theory. That is, PW was stated. Lordship, PW9 and place the
informant or wife Kuntilata Swai.
Yes, Lordship. PW2 is the informant.
Who has stated about the last scene?
PW9.
PW8 and 9. PW8 and 9.
8 and 9.
Trial court reporter.
May I please, Your Lordship?
$76 302.
This one is the charge in 302 crore.
चार चला नहीं बोल रहे अब ये चार्जशीट दीजिए तो
जजमेंट देखिए लास्ट लाइन टा लिखा है 302 लिखा है
charge is only one, right? ये कहाँ रहता है मुंह पर से это more.
Is this matter before some other bench? And which one of us justice CRS is not appointed? After Puja holiday.
Both the appellants are convicted under section 302, 307 and 34 of the Indian Penal Code
And last occasion, my lords, I have prayed for bail for both the appellants. Last occasion, my lord directed to produce the custodial certificate, my lord. This has been filed, my lord, in the record.
କେତେ ଦିନ ହଉଛି?
ହଁ
4016 କଣ ଲେଖାଯିବ?
ଜଣଙ୍କର ହଉଛି
3680, ଜଣଙ୍କର
11 years, ଆଉ ଜଣଙ୍କର 10 years.
Both are more than 10 years.
Yes.
ଆଗରୁ reject ହେଇଛି କି?
Appellant number 2 was released for some time, my lord.
ଆଚ୍ଛା, interim ବେଲେ ଯାଇଥିଲା।
Yes. But appellant number 1 has not been released since the date of arrest, that is 24/9/2013.
appellant number 2 जो बेल ହେଇଥିଲା କହୁଛନ୍ତି କେବେ ହେଇଥିଲା?
ଆଜ୍ଞା 2 ଟା ସେ କୋର୍ଟ ସାର୍ଟିଫିକେଟ ମେନସନ ହେଇತು।
ନା ଏ କୋର୍ଟ ଅର୍ଡର ଯାଇଥିବ ନା ନହେଲେ ପ୍ୟାରୋଲ ଯାଇଥିବ। କୋର୍ଟରେ ତ କିଛି ଅର୍ଡର ନାହିଁ।
ରିଲିଜ ଡେଟ୍ 22/8/22 till the judgment. 22/8/22 till the judgment.
ट्रायल कोर्ट କାରଣ ଆପିଲ କୋର୍ଟରେ ଯାଇନି।
Appellate court ଦେଇଛି ତ ଫାଷ୍ଟ 25/7/23 ଜଜମେଣ୍ଟ ହେଇଛି। till that date he was on bail.
କଣ ଆଲିଗେସନ କଣ?
302 and 307 and 34. Prosecution relied upon the evidence of PW 12 and 13, my lord. Both are claiming as injured eyewitnesses, and but they have not. Their treating doctor has not been examined in this case by the prosecution, my lord.
18 is the doctor. PM doctor.
PM doctor only.
PM doctor देखिए 8 number. 18 number. He was a male, aged about 63 years. So on so. External injury found the following: top wound deep, left wrist, left side forehead, another chop wound on so on so left leg. External injury could have been caused by sharp cutting heavy weapon. External from the death of the deceased. There are 2 eyewitnesses, Mr.
Injured witness.
Key eyewitnesses.
PW 12 and 13, madam. PW 12 with the wife of PW 1. PW
ये होची डॉक्टर है ना PW 18.
18, madam. PW 12, my lord, claiming as eyewitnesses, injured eyewitnesses to the occurrence, but she has not been examined, my lord, by the doctor. As per the IO evidence, my lord, she was absconded from hospital and not been examined, my lord. And PW 13 is concerned, my lord. She is the wife of the deceased.
Applied for both the appellant.
My lord.
Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submits that the appellant number 1, Dhruva Guru, is in judicial custody for Mr. Tripathi. Appellant number 1 कितने है?
At 11 years plus.
देखिन कौन?
Date of arrest.
Wait.
11 years.
11 years. And appellant number 2, Giri Govardhan Guru, is in
10 years, 15 days.
For 10 years.
15 days.
And there are 2 eyewitnesses to the occurrence. That is PW 12 and PW 13. And though it is stated that they are injured eyewitnesses, but no medical evidence have been adduced by the prosecution to proof that they were the injured persons. The Land Council submits that since there is no chance of early hearing of the appeal in the near future, and um, it's a therefore the bail application of the petitioner may be favorably considered. Land Council for the state opposed the prayer for bail and submitted that the evidence of the two eyewitnesses is getting corroboration from the doctor's evidence who conducted post-mortem examination over the dead body. Dr. Vataklegam, PW18. Considering the submission made by the Land Council for the respective parties, the nature of evidence adduced by the eyewitnesses and the post-mortem report finding, while not inclining to release the petitioner on bail on merit, but taking into account their period of detention in judicial custody, we are inclined to release both the appellants on interim bail for a period of 3 months. Yes, date fixed up for those are under certificate.
Item 17. Please, Your Lordship. No prayer for interim bail, my lord. On the ground of the health condition of the wife of the present appellant. And when she is suffering from recurrent hemoptysis since long now.
Having sometime the permission took the child to the house of Anjana. At about 20-25 minutes later, I heard cry.
Answer for the petitioner and conflict with the state. I have the IN number 1817 of 24 is an application for interim bail. Land Council for the petitioners submit that the petitioner the health condition of wife is not good and she is suffering from recurrent hemoptysis. Some medical documents have been annexed to the interim application. Land Council for the state was asked to obtain instruction on the interim application, and he has produced the input of the IHC Chanta Police Station, Bhubaneswar, UPD to show that the OPD ticket and the medical certificate in the name of the wife to the petitioner are genuine. And he also consulted the doctor who issued the medical certificate and advised for further investigation in a higher center. Considering the submission made by the Land Council for the respective party, the government's taken in the entry application, the medical documents filed, and the instruction of death. We are inclined to release the petitioner on interim bail for a period of 1 month from the date of release, subject to conditions. We shall not indulge in any criminal activities, violation of any terms and conditions, and cancellation of the yes, right?
Item number 18.
Matters. The last occasion, my lord was pleased to call for the custody certificate. About 3,536 days as on which comes around 9 years, 8 months for that.
3,536 दिन. It will be
9 years, 7. So,
I go reject it.
no matter.
Case con.
Yes, dispute between two brothers. But the reason of dispute nowhere stated. In the evening, there is a quarrel between two brothers, and the younger brother gave a bamboo stick blow on the head of the elder brother. He was immediately shifted to hospital. On the next morning, he was succumbed to injury. The father is the informant, but subsequently have a glance the P2 group 14. The father.
Mundu Badijan.
Mundu Badijan.
Keteda.
Gote blow se lekhi jati. PW3 is the doctor man.
PW3
दो भाई
cause of death is due to injury resulting from harm or response. और ये उछला बड़ी बड़ी दला
दो जन गंडोल लागिले बाडे दला मुंडो
PW5 is the Land Council for the Petition, Land Council for the State, Land Council for the State has produced the custody certificate of the petitioner from Superintendent District Judge, which shows that he is in judicial custody for 9 years, 7 months now. 7 years. He has also produced the certificate, written instruction received from the OIC, Patna Police Station, to show that there is no criminal antecedent against the petitioner. And counsel for the petitioner submits that the petitioner and the deceased two brothers, and during sudden quarrel, the petitioner stated to have assaulted on the head of the deceased by means of a lathi, which ultimately resulted in his death. He further submits that since there is no charge that the appeal and its appeal of the year 2023, in view of the period of detention, the bail application may be favorably considered. Land Council for the State oppose the prayer for bail and place the evidence of PW5 to Charan of Munda, who is an eyewitness to the occurrence. So also the evidence of PW3, the doctor who conducted post-mortem examination and opined that the cause of death was due to injury to brain resulting hemorrhage from the injured vessel compressing the brain matters by the subdural and exdural hematoma. Considering the submission made by the Land Council for the respective parties, nature of evidence adduced, the relationship between the petitioner and the deceased, the surrounding circumstances under which the offence alleged to have stated to have taken place, the period of detention of the petitioner in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail.
And IA is there for a stay also, stay is also not been granted. Stay of fine that miscase is there. As I filed it subsequently, that is there in the, it has not been scanned, that in the file that is there, that I1 number 189 of 2024. Just check to the file, but it has not been scanned.
What's the number going IA?
I1 number 189 of 2024, my lord.
Acha. After the order in IA number 189 of 2024. There is an application for stay of realization of fine, which is allowed.
Item 19.
My pleasure, Lordship. And last occasion, matter was hard, and the state government took time to appraise your Lordship about
custody certificate तो produce करते हैं
आगे custody certificate produce करची. Here in this case, Millard, the petitioner is in custody 10 years 8 months as per this certificate.
Child was kidnapped and murdered.
This is matter is look at to Millard kidnap and suspectfully murder of this child, where two accused persons Millard was facing trial. And one lady accused was Jasoda Pradhan was Millard acquitted, who, as per the prosecution, she was with the the present accused appellant. Now,
no, 3 persons facing trial.
2 persons.
But your judgment indicates that it is only one. Syria alias Sridhar Mahapatra. Judgment at Annexure 1.
Even charge was against one. Sridhar Mahapatra. Only accused.
Only one person.
Only one person. So what is the question?
That's why acquittal kale. He was also facing trial. Jasoda Pradhan.
Who kale? Judgment pra apon देखोजेन. Judgment रे
जणे
तो अच्छी आउ 2 जण कोट आसले एथर तो नाही.
Again, post.
It may quite the last time to come prepared really. Yes, next.
Item 20.
20 minute prepare after puja vacation.
After puja holidays.
Item 21.
Yes, 21. Next.
Item 22.
My lord, I may be formatted on behalf of Mr. Acharya. Thank you. Last occasion, your lordship directed State Council to obtain criminal antecedent and a custodial certificate.
Ten years, 7 months, 14 days.
Man. The on 23/9/2000.
Shooting for gunshot injury, police sub inspector. After puja holidays, yes.
Okay.
Custody certificate produced taken on site.
Item 23.
This is the case where the 5 persons were murdered.
And after puja holidays.
My lady
Puja holidays, right? Yes, next.
Actually, in CRL 384 of 2024, all the 5 appellants are women. Appellant number 1 is 69 years old.
All right. Yes, item 24.
May it please, my lord. My lordship, on the interim application for condonation of delay, my lordship had sought for instruction on the last occasion from the learned counsel for the state.
On instruction tila?
Lordship.
Delayed about 6 years of delay in preferring the criminal.
In the present case, judgment was pronounced on so therefore report be called for from the concerned jail superintendent as to whether any jail criminal appeal has been preferred by the challenging so And if not void, there was one. अच्छा कौन है लाफोन कर दी
We have already filed.
Right.
Let's objection to the delay. Oh, sorry, madam.
Who jail letter?
It is Rampur jail. Rampur jail under Kodahandi district.
Kodahandi district.
Report of the so and so to be filed लखाई.
Yes, madam. I have not filed yet.
The burden no thila.
Nuapara under Nuapara learned Sessions Court Nuapara ka pakre. But the petitioner is serving his the appellant is serving his sentence in Madanpur Rampur jail in Kodahandi.
But the report says that he was transported to district jail Bhawanipatna.
ଯାହା ଥାଉ ଯୋଉଠି ମାନେ ଏତେ ବର୍ଷ ଧରି କାହିଁ ଫାଇଲ ହେଲାନି ବୋଲି ଆମେ ରିପୋର୍ଟ ଟା ମଗେଇଥିଲୁ ଆପଣ ରିପୋର୍ଟ ଟା ଦେବେ ଯାହା ହେଲେ ଲେଖିକି ଦେବେ ଆଉ କଣ ଫାଇଲ ହେଇଛି କାଳେ ଫାଇଲ ହେଇଯାଇଥିବ କଣ ଏଥିରୁ କିଛି ଜଣା ପଡୁନି ତେଣୁ ଟା ହେଇଛି 2018 ତେଣୁ ରିପୋର୍ଟ ଟା କଣ ଆପଣ ଆଣିନାହାନ୍ତି ନା କଣ He is now in which jail?
Bhawanipatna.
Have you called for the report? ଆମେ ଲେଖିଛୁ ମଧ୍ୟ ଉପରେ provision for quarterly visits so and so SP collector CDM so and so to address the problem ସବୁ ଲେଖା ହେଇଛି ସେଥିପାଇଁ କଣ ପାଇଁ ଡେରି ହେଲା Suppose let us say ଗୋଟେ criminal appeal file ହେଇଥିବ ତା ଏଠି pending ଥିବ କଣ ହେଇଥିବ ଆମେ ନ ଜାଣିଲେ କେମିତି ହବ ଯଦି କହିବେ ନାଇଁ ଆଉ file ହେଇନି ଏଇଟା we condone the delay but life imprisonment is there but we want to know the reason because
May I be pardoned, my lord, for interruption. On the last occasions, I had inquired from the learned Madam Counsel who was appearing for the state, and she had said that she had sought for the report. And the jail authorities had communicated her that District Legal Service Authority Cuttack को communicate कर देथिले. There was some communication gap there, because of which no criminal appeal could be filed, my lord. So, criminal appeal by the present appellant in any other form is not pending before my lordship.
There must something must come on record say ସେଟା ଯଦି ହେଇଥିବ ତ ଆଣି ରିପୋର୍ଟ ଦବା କଥା ନା ଯଦି ଏମିତି ଅଛି କିଛି ଆପଣଙ୍କ ପାଖରେ
in every district there is a legal advice they will send it to Cuttack.
କଳାହାଣ୍ଡି ରେ ଦେଇଥିଲେ ସେମାନେ କଟକକୁ ପଠେଇଥିଲେ
ପଠେଇବା ତ କିଛି justification ନାହିଁ
ତାଙ୍କର ସେଠି ଗୋଟେ ନମ୍ବର ଲେଖାଯାଏ ଜେଲ କ୍ରିମିନାଲ ଅପିଲ ବା କ୍ରିମିନାଲ ଅପିଲ ହେଇଗଲା ମାନେ ସେ ଯୋଉ ଜେଲ ରେକର୍ଡରେ ଏଣ୍ଟ୍ରି ହେଇଯାଏ ତେଣୁ ଓବିୟସଲି ଯଦି ହେଇଥାନ୍ତା ସେମାନେ ଜାଣି ପାରିବେ ସେଇଥିପାଇଁ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟକୁ ମଗା ହେଇଥିଲା
My lordship, I had inquired from the superintendent. କିଛି ଫାଇଲ ହେଇନଥିଲା
Mahapra was convicted. This said convict was submit the petition. Honorable DLS Noapada.
ଦେଖନ୍ତୁ ସେ ଲେଖା ହେଇଛି ଦି ସେଡ୍ କନଭିକ୍ଟ ୱାଜ ଟ୍ରାନ୍ସଫର୍ଡ ଟୁ ଦି ଡିଷ୍ଟ୍ରିକ୍ଟ ଜେଲ ଭବାନୀପାଟଣା ଅନ୍ 20/9/2018 ଫର ଫର୍ଦର କନଫାଇନମେଣ୍ଟ ମାନେ ଜଜମେଣ୍ଟ ହେଲା ପରଠୁ ସେ ଯାଏଁ ଜଜମେଣ୍ଟ ହେଇଛି 10/9/2018 ତାପରଠୁ ପଳେଇ ଯାଇଛି ଭବାନୀପାଟଣାରେ ତେଣୁ ଭବାନୀପାଟଣାରେ ସେ ଅଛି ତେଣୁ ଭବାନୀପାଟଣା ଏମାନେ କହିଦେବେ
Lordship, sir, Rampur ଅଛି।
For appeal for Honorable High Court in Orissa, ଏମାନେ ଦେଇଥିଲେ DLS ନୂଆପଡାକୁ, not Cuttack.
I'm sorry, my lord, but
been sent to the Nuapara. 2018 ଆସିଛି। ଯଦି ସେଇ 2018 ମସିହା ବଳରେ ଯଦି ଇଏ ହେଇଥିବ ତାହେଲେ ଇମିଡିଏଟଲି ତାଙ୍କୁ କମ୍ୟୁନିକେଟ ହେଇଥିବ ନମ୍ବରଟା।
ମୁଁ ଭେରିଫାଇ କଲି my lord, ଫାଇଲ ହେଇନି କିଛି। ଯୋଉ ହାଇକୋର୍ଟ ୱେବସାଇଟ ରେ ୟାଙ୍କ ନାଁରେ ଚେକ୍ କଲି ଆଉ ସେ actually ଏବେ ଲଜ୍ ରାମପୁର ଜେଲରେ my lord. Lordship, if kindly sees my wakalatnama, the endorsement is from the learned jail authority Rampur. So jail Rampur.
ରିମାଣ୍ଡରେ ଥିବ ବୋଧେ ଆଉ କୋଟି
ତ ତାଙ୍କୁ ମୁଁ ପଚାରିଲି, ସେ କହିଲେ ଯେ ନା ତାର କିଛି ସେମିତି ଜେଲ କ୍ରିମିନାଲ ବିଜନେସ ପିଟିସନ କିଛି ଯାଇନି ଜେଲ ଆଉ
ଏନିୱେ DLS ବି କିଛି କରିନାହିଁ ଯାହା ଜଣା ପଡୁଛି। 18 ରୁ ଆସିଲାଣି। If at all any move was there, it was only in the year 2018 when the matter came to the notice of DLSA. But କିଛି ହେଇନି। ହେଲେ ତ ଆମେ 24 ରେ ଦେଖିଥାନ୍ତେ। ଏଇଟା 24 ରେ ଫାଇଲିଂ। ପାଇଲେ କିନ୍ତୁ
ପଚାରିଦେବ ସେକ୍ରେଟାରୀ ଆଗ ଓଡ଼ିଶା ହାଇକୋର୍ଟ ଇଏର ସିଏ କଥା ପାଇଛୁ କି ନାହିଁ ଆଉ ପାଇଛୁ ଯଦି କିଛି ଆପିଲ ଫାଇଲ ହେଇଛି।
DLS ସେକ୍ରେଟାରୀ DLS ପଠେଇଲା ଏଇଟା ରେଗୁଲାର ଏଇଟା କାଳେ ଦେଇଛି ଦେଖିଦେବା।
The Learning Council for the state has produced the letter of the Superintendent Sub-Jail Nuapada dated 19/9/2024, from which it appears that the appellant, after his conviction, was transferred to District Jail Bhawanipatna on 30/9/2018 for further confinement, and the appeal petition was sent by the Secretary DLSA Nuapada to the Deputy Secretary OSL SA Kamar Patak, Orissa State Legal Service. Vide letter number 1534 dated 29/10/2018. Stop. Let a ଗୋଟେ copy enclosed ଦେଖାଇ ସେଇଟା ପଠେଇଛନ୍ତି ନା ନାଇଁ? ଖାଲି ପଠେଇଛନ୍ତି। Let a report be called for from the Deputy Secretary so and so whether any such communication has been received.
Member secretary
Member Secretary State Legal Services Services Authority Qatar as to whether they have received any such letter
and
taken action, and if so, and taken action thereof. I'll put up this matter after cancelling puja already.
Item 25.
engagement.
ଏଇଟା 271 ଦିଲେ କଲମ ପର୍ଯ୍ୟନ୍ତ ଆଉ ସାର୍ ଏନଗେଜ କରିଦେବେ।
25/26
ତାପରେ ଏଇଟା କଣ ସେକେଣ୍ଡଟା କଣ୍ଡିସନ 302 ଲାଇଫ ଫର୍ମ बाकी यूजुअल ऑर्डर लिखते हैं for the trial court report, so and so is engaged. Okay, the password matter. Password order actually
Password item number 1.
I submit the report.
Contact.
The report was called for.
Interim bed.
Yes.
ରଖିଥାନ୍ତି ସେ ତ ନାହାନ୍ତି ଆଉ ଏଟା ନନ୍ ଆପିୟର୍ସ କରିଦେଇକି ମୁଁ ଅପଲୋଡ ପୂଜା ରିଡେସ୍ କରିଦେବେ ହେଲା।
Item 21.
On behalf of Mr. Mishra, I pray for an adjournment. He is on his way.
Mention is made on behalf of Mr. Tushar Kumar Mishra to adjourn the matter after puja holiday, after puja.